This courtroom moment starts off with a shocker, a defendant caught red-handed lying to the court, but trying to spin it with a non-alcoholic beer defense. Today we're diving into the jaw-dropping case of Sereno Johnson, who claims he was sipping O'Dow's but ultimately admits to downing actual beer, violating the terms of his bond. But it's not just the lights, how he tried to manipulate the system, and how the judge dismantles his story with cold, calculated precision. What begins as a simple probation hearing spirals into a brutal courtroom takedown. We'll also cover another defendant later who tries to charm the court with a group effort, plea bargain, but not before one judge exposes every missing detail. If you're into high-stakes courtroom drama, legal breakdowns, and jaw-dropping moments of truth, this one's for you.
Public Defender Chelsea Vergils with and on behalf of Sereno Johnson. Mr. Johnson, please state your name.
Sereno Johnson.
I mispronounce your name every time, sir. Okay, I apologize.
Thank you, Your Honor. Today is the time and date set for a probable cause conference. Regarding that, we are asking for an adjournment to show compliance with his bond conditions. I understand he's had a violation that we are prepared to deal with today.
All right.
Mr. Johnson is prepared to plead guilty to violating his bond by consuming alcohol on July 7th.
And I'll accept that. Before imposing any sentence regarding that, I'm going to ask this question. He presumably has indicated that he had O'Doul's. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
Here's where things get wild. The judge isn't just skeptical, she's practically daring him to tell the truth. When Johnson's attorney admits he'll no longer claim it was just O'Dow's, the whole courtroom energy shifts. Why? Because lying to pretrial services can tank your credibility and your freedom. This isn't just about a few drinks. It's about whether the court can trust you. And Johnson, he's already stumbling.
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That is correct, Your Honor.
And why'd you tell everybody O'Doul?
I had O'Doul's first, but I needed beer.
You had O'Doul?
Yeah. I don't look like what I'm going through.
No.
I had O'Doul's.
Are you
I had
tell me that? So did you tell them that?
Yes.
That you had O'Doul's first and then had beer?
Maybe I omitted the beers, but yes.
What?
I omitted the beers.
Hold it. You know what, sir? Don't play fast and loose.
I got
The
you.
story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes.
How many?
6.
Did you catch that? The judge does the math. To reach his BAC level with O'Dow's, he'd have to drink 25 non-alcoholic beers in an hour without using the restroom. That's not just biologically impossible, it's courtroom comedy gold. This is the kind of logic-busting moment that obliterates a defense. How would you react if your excuse collapsed under a math equation?
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because you're violating your bond condition.
Indeed.
So, first of all, we did the calculation because the only story you gave is that you had O'Doul's. To get to the level that you were at, you would have had to have 25 O'Doul's in an hour.
No, I didn't have
in
that.
order to reach that level,
Sure.
and could not have use the bathroom because you couldn't eliminate in order to get to that level. That's how stupid your story was. And now you can't even, you can't bring yourself to say that you were intentionally lying to them and attempting to mislead them.
The defense tries to call it an omission, but the judge, she calls it what it is, a lie, and that distinction matters. In court, intent is everything. When you deliberately leave out key facts to dodge consequences, that's not just a mistake, it's manipulation, and the judge is having none of it.
It was not just a simple omission. Counsel, what did you want me to do with this case?
Regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders. I
Well,
understand.
I don't think he's going to have a choice on that, quite frankly, Mr.
You're-
Allen.
We are asking for him to remain out of custody today. This would be his first bond violation. He is here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
Really?
He's here.
No, he was not being honest. I asked him the question and then asked him the question of why didn't he tell them? And he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of that.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has a substance.
The defense scrambles, painting Johnson as a business owner, a volunteer, a man under pressure, but it's too little, too late. The judge cuts through the emotional appeal, asking the real question, can he be trusted to follow court orders? One violation might be forgivable, but lying, that's another story.
And he wants to get help for that. He's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a scram tether. Again, this would be his first violation. And he is asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have some concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. I think it's just a couple of years. We would note that in this case, he allegedly was found not awake in a vehicle that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do.
Here's the twist. While the defense pleads for leniency, the prosecution quietly reminds the court, this isn't Johnson's first rodeo. He's previously been found with 2 firearms in public. He's only charged with 1, but that detail raises the stakes dramatically. This isn't just a drink violation, it's about public safety. Would you release someone with that record?
Have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I
The
do.
way that he does admit that is he stops lying. Defendant's bond at this time is revoked.
Boom. The judge has heard enough. Bond revoked. The message is clear. In this courtroom, honesty matters, and if you lie, you pay the price. It's a turning point that leaves no room for negotiation. Johnson goes from pleading for freedom to losing it in seconds.
Defendant's remanded.
Anna Mackey on behalf of Mr. Haywood, who is approaching to my right. Please state your name for the record.
Good morning, Your Honor. Devon Hayward.
Thank you.
Your Honor, I believe you reached a resolution in this matter.
You have. And it's here.
Perfect.
That's right. This is the one that, hang on a second, I just want to make sure this is the one that I looked at. All right. We have a plea form in this case that the defendant would be pleading to the charge of use of a controlled substance. I don't have, how come these forms aren't that hard to fill out?
Just when you think things might calm down, we jump into a new case with Devin Haywood. But instead of deception, we get comedy. The plea form is incomplete. The defense blames a group effort, and everyone's suddenly trying to cover each other's tracks. It's like watching a courtroom group project gone sideways. You ever see a team effort fall apart in public?
Pardon?
How come I don't have the maximum penalty on here of what he's pleading to? Who did this? Mr. Childers? Mr. Childers, type. Childers, you know what? No, you know what? It's typed. Did you type it?
No, I did.
You didn't. Who did?
It was a group effort, but I'll take.
I appreciate Ms. Mackey because she provided me with the basic love. This is I think we're both at fault here.
It just felt.
She provided me with a mostly typed out plea form. All I did was look at it, sign it, and send it back to her.
Because if it was up to me.
I fill these out myself. I
Correct.
appreciate Ms. Mackey doing my work for me. I'm not gonna, stop there.
Well, she had did it.
Yeah, and so we will.
I wasn't going to put a max penalty for my client.
What?
It felt wrong to like do that part. So I was like,
That hurt. I just couldn't write that. I couldn't type that part. What is the maximum penalty on the one that? Pardon?
Let's pause on this gem. The attorney says it felt wrong to type the maximum penalty for her own client. That might sound noble, but in reality, it undermines court procedure. Judges need facts. Leaving out the harsh parts doesn't protect your clients. It can backfire. The judge isn't mad, just baffled. And that's worse.
1 year.
1 year, 2000. It was a group effort. I like how
Never
they
do
all
that
sat
again.
there and tried to protect each other. All right. May I have him sworn?
Solemnly sworn to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God. I do. State your name. Devon Haywood.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of use of a controlled substance. That's a misdemeanor, punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that, sir?
I do, Your Honor.
Do you understand what a no contest plea is?
Yes, I do, Your Honor.
All right, two things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
I do.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I understand.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Watt.
Haywood pleads no contest, which many think is a free pass. But here's the truth. It's almost the same as pleading guilty. The court still treats it as an admission for sentencing. It's often used to avoid civil liability, but the punishment, that still lands. So don't be fooled by the language. No contest still packs legal consequences.
Washington in the 14B District Court. You understand that?
I do.
All right. Basis for the no contest plea.
civil liability, Your Honor.
All right. And sir, to this charge, how do you plead?
No contest.
Now you understand that by pleading no contest, you will not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct, sir?
Yes, sir, Your Honor.
Do you have any question regarding any of those rights?
No, sir, Your Honor.
All right. Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am. I'm on probation for, explain the case.
Well, were you on probation at the time of this offense?
No, Your Honor.
All right.
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
All right. The court has been provided Washington County Sheriff's Office report, and I've also reviewed that report for their case number 24-42704. Any objection to the court having reviewed that report?
Okay.
None from us, Your Honor.
All right. Sir, you also understand that if between the time I accept your plea, if I accept your plea, and the time of sentencing, if you commit misconduct as defined by the court rule two things would occur. You would not be entitled to set aside your plea, and the court would not be bound by any sentence agreement and/or
The judge lays it out. If Haywood misbehaves between now and sentencing, the deal is off. That means no plea reversal, no sentence guarantees. It's a legal trapdoor, one slip, and everything changes. The court is offering trust but conditional. Would you stay clean, under pressure, knowing your freedom is on the line?
evaluation of your case. You understand that, sir?
I do.
All right. Based upon the review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt. Before I accept this plea, is counsel aware of any other promises, threats, or other inducements which have caused this plea?
Not objective people.
None, Your Honor.
All right. Court will accept the defendant's plea of no contest to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
August 14th, 2025 at 10 a.m. in Judge Washington.
August 14th, 2025. What time?
10 a.m.
10 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you. Thank you, sir. Court calls the case People versus Derek Stevenson.
Two very different defendants, two very different outcomes. Sereno Johnson's downfall came not from his actions, but from his dishonesty. His lie, small as it seemed, cost him his freedom. Meanwhile, Devin Haywood navigated his case with transparency, even if a bit messy. Both remind us, the courtroom isn't just about rules, it's about respecting the truth. And in front of a sharp judge, the truth always comes out. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. You won't want to miss what's coming next.